CETA says, I have a specific situation with a property Stokvel, where 5 members have been equally contributing for an investment property. Now that a Pty Limited has been incorporated and is applying for finance in the name of this entity, comes an issue. And the issue is that 2 of these directors from the 5 are not qualifying for finance, but 3 are. She says, how best can this be looked at and what structure can be put in place? And we want something in writing. Looking at the shareholding, suretyship, and compensation for suretyship versus just investing cash into it. Cilna, what do you advise CETA in this particular situation?
CETA, oh my goodness. So I think Bruno was making calculations in his head, but let me see how far we can get. Actually, while I listened to the question, actually something popped up. I think it's actually a relatively simple issue to resolve. What I mean is, if they are talking about a new company now, a company that's been formed, and the directors, 2 of them don't qualify for finance, what do we do? Luckily, it's not the biggest deal. Initially, I thought, when I read the question quickly, I thought, this could be a problem. It's something that I would like to see dealt with in terms of the constitution of the Stokvel, because remember, the document that you use in a Stokvel is typically called the Constitution. It's similar much to the Memorandum of Incorporation or whatever. But typically, a Stokvel, I think what happens often, this is actually an exciting part of the South African law, is the more proper legal development around Stokvels. I think the common law and the typical way Stokvels are used is so well developed, actually, but it's not properly incorporated into our law yet. What I mean by that, not proper case law and things protecting Stokvels. And there are actually legislation that I think applies strongly on Stokvels, like the Consumer Protection Act and things like that. But the point in this situation is the purpose of this association, Stokvel, organization, partnership, call it what you want. The intention was from the start to buy a property with shared funds, typically in the context of a Stokvel, equal shares, equal contribution to the fund, and then equal distribution to the other side. But a Stokvel is actually something that can have a relatively simple baby with a joint venture agreement. The nature and the basis of the thing is similar enough that we can borrow parts from the 2. So the fact that we went from Stokvel into PTY tells me that now the nature of the transaction changed. The money that was collected in terms of the Stokvel, I do assume, would have been used to set up this company and things like that. But now we have a company. And in terms of this company, we can either use the Memorandum of Incorporation to deal with this. I think that's a little too permanent in a company to do that. But you can have a resolution and you can have a joint venture agreement. And I am back to the joint venture agreement between the Stokvel and this corporate entity. And the members of the Stokvel then agree that the parties that does qualify for a bond will be the parties that is responsible for the bond, but the guys that doesn't qualify for the bond undertakes in a specific way, and this is how we record it then in an agreement. Please keep it in writing, Yella. Really, I don't easily beg, but this is a beg moment. Please record exactly in writing what the parties agree to. This is typically one of those things that I suggest you go to Bruno for or come to us for, that we draft a detailed contract, because yes, it's going to cost you something in legal fees to draft a contract like that. But I promise you the litigation at the end, if the contract wasn't done properly or at all, is at least times 100 of what the contract is going to cost you. So it really worth your while. I would suggest that you do something like say, okay, these 2 people will get the bond. but the other 3 will benefit from that, and they will assist to service the bond. Give a form of surety, because remember, the 2 guys that's going to get the bond, they're going to have to sign personal surety. I can promise you that in the context of a PTY. So we can add those guys as sureties, or even do a separate surety as part of this joint venture project. So there are luckily ways that we can plug that hole, and but make sure it is properly done in writing.
Sure.
Did I miss something, Bruno?
No, absolutely. It makes total sense. We've done a lot of Stokvel transactions exactly like that, with the Stokvel remaining intact, and basically using a company to move the funds across. If for some reason you guys did the Stokvel already in a company, which is fine, because a Stokvel takes many different shapes and forms. So if it's already in a company, what we've sometimes done if financing becomes an issue is remove them as directors. As long as it's close to the bank will ask who the shareholders are. Typically, if the directors are the shareholders, they don't have a problem, even if there's other shareholders. The banks tend to have a difficulty in granting loans if for some reason you've got a director who isn't a shareholder, and you're trying to use his affordability to get a loan, but he doesn't have a vested interest in the company. That I've experienced issues with. So yeah, if it's already done and dusted, remove the directors and keep only the ones that are good. And if the ones that are removed are now worried that they lose control over the property, bear in mind that the bank doesn't actually mind if you appoint them back later. It's not actually an issue, so you can just appoint them back later, or you can just change the voting rights in the MOI so that more serious decisions are taken by shareholders and not the directors.
Thank you so much, guys. You know what I loved about that, Cilna? I knew you thought I was going to ask Bruno that question, but yet you guys are so amazing that it just doesn't matter which way I throw it. I keep you on your toes, and the viewers still get the answers they need.